in Oyetola and
Hello,
INEC
ladies and gentlemen.
made
Welcome
it
to
clear
Season AY, the
that
platform where we
there
speak
is
truth
a
to power.
difference
You're
between a
watching the
collation
broadcast
system
of
and the IREP portal, though
the
both are part of the
courts in the
election
case
process.
taken to court by
Whereas
jointly,
the
I believe,
election
by
system is made
Atiku
up of
and of
the
course
centers where
PDP
results are
and Labour
collated
Party, as
at
it were,
various stages
on
of the
the
election.
merits,
The
the
INEC result viewing portal
certificate saga,
is to
and
give the public the
yeah, it
opportunity
looks
to
like the
view
results are
the
coming in,
polling unit
the verdict is
results
coming in, and it
on
looks like the
election day.
president will be in place. But
What
let's
this
listen on.
means
We'll come and
is that
interject as we watch.
where the
Please do
IREP
share this
portal
broadcast. You're watching
fails,
Season AY, the platform
it does
where we
not
speak
stop the
truth
collation
to power.
of results,
Let's
which
see how
up
it
to
goes.
the
Let's see
last
how this
election
goes. We're
was
following it with keen
manually
interest here.
done.
So
The
let's go.
failure or malfunctioning of the IREP deprives the public and even election administrators and monitors the opportunity of viewing the portal and comparing the result collated with the ones transmitted into the IREP. Truth must be told. The non-functioning of the IREP may also reduce confidence of the voting public in the electoral process. My lords, the Electoral Act empowers the first respondent to determine the electronic device to be used during election and their purpose. The lower court held that the IREP is not a collation system, and I agree. I refer to paragraph 93 of the first respondents guidelines and regulations for election, which provides that, and I quote, where the INEC hard copy of collated results from the immediate lower level of collation does not exist, the collation officer shall use electronically transmitted results or results from the IREP portal to continue collation. When none of this exists, the collation officer shall ask for duplicate hard copies issued by the commission to the following in the order below. 1, the Nigeria Police Force, and 2, agents of political parties. End of quote. Paragraph 93 of the first respondents guidelines and regulations reproduced above shows clearly that recourse to the electronically transmitted result for the purpose of collation will only arise where the hard copy of the result sheet does not exist. Given when the electronically transmitted result or the result on the IREP portal does not exist, the Commission will ask the copies handed over to the Nigeria Police or agents of political parties. The elaborate arrangement made by the first respondent for collation of results is to make sure that at every point of collation, there is a result either from the hard copy with INEC or the electronically transmitted copy or the IREP portal copy or a hard copy given to the Nigeria Police, and finally, or a copy given to political parties. I think I can confidently say, and in agreement with the respondents, that the unavailability of the election results on the IREP portal, for whatever reason, cannot be a ground upon which an election could be nullified, particularly as it is not the case of the appellants that the hard copies of the result sheets did not exist at any level of collation. My lords, having failed to
There's some sort of delay. We're seeing what's going on. We'll hope they will continue. Let's watch. Yeah.
approachments with the or that there was any miscarriage of justice since of this started. Section on the establishment electoral relied upon by the appellants for the failure to prove non-compliance in the manner whereby used to provide. I quote, it shall not be necessary for a party that is non-compliant
Okay, something's going wrong. It's a bit temperamental. I hope they're gonna fix it. So We're not too sure what's happening. It looks like there's some sort of issue here. So we're watching, we're following. I may have to do something with this. It's echoing somewhat. Okay, let me just check here quickly, right quick. We're just gonna try and bring it back. 1 second, please. Trying to make sure it really does what it needs to do. It seems to have just gone awry somewhat. We're gonna try and bring you as much as we can, so just bear with me. I think something has gone wrong. I'm not quite sure what, but you can see that we've lost audio, so we are working on that. I'm hoping that it resolves quickly. There's one thing I want to say, and I want to reiterate this very strongly. I think one of the things that I'm not interested in this court case. I'm not. Me personally, as you know, Citizen by the platform where we speak with power. It is of no interest to me, whoever wins this case. There has been a number of precedents, if you like, that has been in place. When the President Buhari had issues with his certificate, he served his full 8-year term. So there's no reason to believe that this will not be the case in this situation as well, because of the issue of the precedents. It's not going to be spoken about, but that's the reality. There is the issue also that Atiku has got concerns about his own certificate. So it really brings into question a lot of things. But I want us to focus on something. The people in power now, they believe that they can do as they please and get away with it. And I think that is where you and I come in. That is why I am adamant about us knowing the powers we possess. I don't think we should focus. I no longer subscribe to the idea of focusing on the powers of those in government and expecting them to do the right thing by the people. I just don't buy that. I'm trying to see if it's going to come back. Something is muted. I cannot hear anything. So, but what I think we should be doing is to begin to really educate ourselves within our community about the powers that we collectively possess as citizens. The court case, either way, wherever the court case goes, I'm telling you that it's going to make no difference in the lives of our people. You and I need to make that change. And that's what I am really focused on, relentlessly focused on. And that's why I am committed. I've recommitted myself to ensuring that the best way for us to ensure that we ultimately get the self-determination. And let me be very, very clear about this. I am for self-determination for Yoruba people, for Biafrans, for Middle Beltans, for Hauses. I am for that. Because as far as I'm concerned, what you're looking at as a nation is a construct that remains in place under the name of the colonials who created it. We've seen what has been happening across many African countries, 14 African countries. Niger have put themselves out for the first time. Niger, Mali, Burkina Faso, and Guinea, they put themselves out of this French construct by saying, no, we no longer want to use your CFA. We don't want to be part of you because you've been oppressing us. It's the same thing with us in Nigeria. Whether the people in power know it or not, whether they know that they are being used to actually achieve a greater end for the colonials or not, we know, and we need to begin to confront it. If we want a better future for the coming generation, then we need to exercise this. Sorry about this. I'm going to just bring that up there. Okay, we need to exercise what you're about to see on the screen. I will come back and look at I'll get some updates on that because I'm not quite sure what's happened with the voice. It's just gone. But it doesn't matter. I am, like I said, I am more than 100% certain that you're not going to get a different outcome. You're not. Sorry about this. You're not going to get a different outcome than what we just said. It is not going to be any different. I'm sorry to say it, but that is the reality that we face. So rather than focusing on something that we will have no control over, I think it is time for us to focus on the things that we can indeed have control over. And that is why you're seeing what you're seeing in the middle of the screen there. And I want you to sort of familiarize yourself with it. By the way, if you are watching us, you're watching Citizenwide, the platform where we speak truth to power. You need to focus on the powers that you possess collectively as citizens. That is what we must do. The political system, the governance is it's riddled with corruption, and it is not going to be resolved anytime soon. We have to be sure of one thing: what you see on the screen. We have to be very certain, and we need to spread the word about the fact that we are sovereigns. And I'm saying it again. Many of you who are watching, who follow Citizenwide, the platform where we speak truth to power, please, by the way, if you haven't subscribed, go ahead. Subscribe to Citizenwide. Subscribe, hit the notification button, give us thumbs up, help us reach more people. We need your support. Subscribe, hit the notification button, give us thumbs up. We are here to tell you exactly how things are. The result, whatever the result today, it's not going to drop the price of Naira against the dollar. Let me say that again. Whatever the result today will not drop the price of the dollar, Naira against the dollar. As in case many of you may not be aware, the Naira is now 1,500 Naira to the dollar. The Naira is now 1,500 Naira to $1. To $1. Whoever becomes a president, whether it's Peter Tinubu, whether it's Peter Obi, whether it's Atiku, will not change that reality. Because whoever is going to go into power will only be allowed to go into power committed to agreements reached about the continuation of Nigeria being linked to the economic plans of the U.S. and the Western world, and for all intents and purposes, colonialism. The powers of colonialism are in control of Nigeria. And that is what is the biggest problem that we face. And I wanted to just state that, and really make sure we understand what is going on. So let me read this to you. Please, every community needs to know this, and we want you to please share this as you get it. I'm going to leave something on here, and I'm going to change something. Today, of course, being the 26th, beg your pardon. Today being the 26th of October. Okay, so we're soon going to be in November in due course. 26th of October. So let me read this to you, and please do share it. We cannot rely on any of the politicians from any of the parties for giving us good governance. In fact, the absence of we, the people, in our governance through active participation will only ensure that the politicians will make empty promises. They will continue to make empty promises, and they will continue to impoverish the sovereigns they're supposed to serve. As it states on here, it states, sovereignty belongs to the people of Nigeria, from whom the government, through its constitution, derives all its powers and authority. That is what you are. You watching me, you are a sovereign. We need to exercise those powers. How do we exercise those powers? It's again on the screen right there, and I'm showing you. It says, Section 14.2c, the participation by the people in the government shall be ensured in accordance with the provisions of this Constitution. And the participation, the provisions of the Constitution is that we are sovereigns. Never forget that. We need to exercise those powers. They've used the religions to blind us. We are telling you to wake up. We are telling you it is now time to rise and to wake up. And I wanted to just state that. So I will come back. I'll be showing this. Let us see what is going on right now. Something is going on. I can't quite see what's going on, but we'll come back.
Will not be entertained after the statutory time limit for the filing of petition has expired. Thus, a petitioner cannot present his case will be breached. This was the position of this court in Oke and Mimiko, citation supplied. In his contributory judgment in the above case, Clara Ogumbiyi JS retired, made the following decision, and I quote, by paragraph 4, sub 1 and 5 of the first schedule to the Electoral Act, a composite analysis of the contents of an election petition has been spelled out, and also a list of materials which must be accompanied. The use of the word shall in the subsections is very instructive. It is mandatory and conclusive. In other words, the provisions do not allow for additions, and hence the procedure adopted by the appellants in seeking for extension of time is nothing other than surreptitious attempt.
Which provides for extension of time. What is more, via paragraph 14.2 of the first schedule to the Electoral Act, the appellants by section 134 Act had been totally foreclosed from any amendment, which was in fact the hidden agenda promoting application. Further still, and on a critical perusal of the application, Relief 2 seeks leave to call additional witnesses, to wit AEO. It is pertinent to restate that at the close of pleadings, parties had submitted the list of witnesses who were to testify together with their deposition. The idea, purpose, and intention of the application is suggestive of nothing more than a clear confirmation, seeking an order for an amendment as rightly and ingeniously thought out by the trial tribunal and also affirmed by the lower court. This will certainly violate the provisions of section 285 sub 5 of the Constitution and section 134 of the Electoral Acts. End of quote. It has to be emphasized that the use of the word shall in paragraph 4.1 and 5 of the first schedule to the Electoral Act makes it mandatory and conclusive. The question may be asked, can a court extend time circumscribed by the Constitution for a party to do a thing he could not do before the expiration? The obvious answer is no. Such provisions like section 85 sub 5 of the Constitution are mandatory, and any exercise of discretion by the court is without jurisdiction and therefore a nullity. In APC and Marafa, citation supplied, this court held that application of time to call additional and file additional witnesses statements after the prescribed period for presenting election petition are not permitted because election matters are time-bound, and by reason of being sui generis, the procedure in handling them are stricter than ordinary civil matters. See also Ararume and INEC citation supplied.
Okay.
Compel the impossibility, and that subpoenaed witnesses should be allowed to testify. But as was argued by the learned respondent, A.B. Mahmoud SN, subpoenas.
So let's see.
And the effect and purpose of 5 of the Constitution of the Federal Republic of Nigeria and paragraph 4.5 of the first schedule to the Electoral Act 2022. It is on this note that I hold that the decision of the court below to strike out the offending witness depositions cannot be faulted. I resolve this issue against the appellants. Issue 4 orbits around the evaluation of evidence of PW1, PW2, 3, 5, 7, and 22, who were the appellants' collation agents at the court below. The appellants are aggrieved by the verdict of the court that witnesses a hearsay, thus inadmissible under the rule of evidence. For the purpose of clarity, I shall herein reproduce, albeit extensively, court below, which led to the verdicts complained about as follows. Quote, the petitioners, it must be underlined, there are 4 of the petition that the petitioners had agents in all the polling units, collation centers, local government collation centers, and state collation centers in all the states of the Federation and the Federal Capital Territory, as well as the national collation centers. Of this crowd of agents, the petitioners did not call any of their agents at the polling units. The said agents at the polling units were the ones who were meant to sign and collect duplicate results in Form EC8A. The few agents called were state and national collation agents. Largely, their testimonies were hearsay. Let us now examine their evidence before the court. The PW1 is Captain Joe Agada, retired. His statement on oath is at pages 198 to 200 of the petition. He was the petitioner's collation agent for Kogi State. In paragraph 7, 8, and 11 of his statement, he deposed that from the analysis, he discovered various forms of non-compliance and corrupt practices such as suppression of votes, manipulation of the beavers machines, manipulation of accreditation, intimidation and harassment of voters, massive thumb printing of ballot papers, etc. This witness did not give particulars of these malpractices. There was no forensic report to support allegation of thumb printing at the polling units. In PDP and INEC, citation supplied, this court, per Agim JCA, as it then was, held that it is only a polling unit agent or a person who was present at the polling unit during polls that can give admissible evidence of what transpired during the poll in that unit. See some cases cited there. In the instant case, he was a collation agent. When cross-examined, he said he would be wrong to say that he was present when all the ballot papers and boxes were manipulated, that he visited only 20 polling units out of the over 3,000 polling units in Kogi State. He admitted that his party had polling agents in all the polling units and that they were still alive. The PW2 is also a collation agent. His witness statement on oath is at pages 213 to 215 of the petition. His statement is similar to that of the PW1. He is Dr. Folarin Sunday Adekunle. He was the collation agent of the petitioner for Ogun State on the election day. Under cross-examination, he said he only visited 19 polling units out of the 5,040 of the polling units in Ogun State. PW3, PW4, 5, 6, 7, 8, 9, 10, 11 are all collation agents. The evidence of these witnesses centered around the events and the duties they carried out by the polling units agents of the petitioners. They agreed under cross-examination that the polling unit agents functioned very well in their units under our law. Specifically, in Section 43 of the Electoral Act 2022, polling agents are permitted to to be appointed by political parties for each polling unit and collation center. The wisdom in this is for each of the political parties involved in an election to be represented by its own agents. The duties of an agent are to represent the interests of his or principal, having regard to the fact that no mortal can be in all the places at the same time. The law allows political parties to have their agents at all polling units and collation centers. It is therefore not anticipated by law for any political party to appoint an octopus agent with his tentacles in all the polling units and collation centers. This is humanly not practicable. When, therefore, evidence is required to prove what happened in any polling unit or collation center, it is only the agent who witnessed the anomaly or the malfeasance that can legally and credibly testify. It follows, therefore, that PW1, PW2, PW3, PW4, PW5, 6, 7, 8, 9, 10, 11, 19, 20, 22,
Please don't forget.
who were state and national coalition agents of the petitioners, can only testify of the events in their units or coalition centers where they voted or acted as agents, and not all over the states of the Federation.
Nothing else.
Polling agents, as presented in this petition, it must be noted, are not shown to be experts.
Nothing else.
The issue of their analyzing results of the election at the ward, local government, state, and national level without calling polling unit agents who witness the real casting of votes and events at the voting units cannot therefore arise. They cannot validly testify as of non-compliance at the polling unit level. Their evidence can only count as to what they saw, not what they were told by their field agents. What they were told is hearsay evidence. Section 38 of the Evidence Act 2011 specifically states that hearsay evidence is not admissible except as provided for in the law. It follows that the evidence of the coalition agents in this instant case, who are PW1, 2, 5, and 7, relating to suppression of votes, multiple thumb printing of ballot papers, entering of wrong scores results, disruption of voting, are inadmissible hearsay and are hereby discounted as end of quote. Without reservation, I endorse the above statement of the lower court, which is consistent with plethora of decided cases on the subject. Buhari and Obasanjo, Ladoja and Jumobi, and others cited. From the evidence on record, it is indisputable that PW1, 2, 3, 5, and 7, who were the appellant state coalition agents and national coalition agents, were not present in all the polling units, which results they have disputed, which means that their evidence in respect of all the polling units, other than the ones that they were present, were clearly hearsay. They were most likely informed by the polling unit agents who were alive but failed to testify. I must say that the above statement of the lower court had nothing to do with the court's failure to ascribe probative value to documents put in evidence pursuant to Section 137 of the Electoral Act 2022 and paragraph 46(4) of the first schedule to the Electoral Act, as vehemently submitted by the appellants. Indeed, the point is instructive in view of the fact that the court had earlier on page 8,102 of the record rejected and overruled the third respondent's preliminary objection, seeking that documents tendered by the appellant be expunged for being dumped on the court. The finding of the lower court in discountenancing the evidence, analysis of PW1, 2, 3, 5, and 7, same being based on hearsay, cannot be faulted. More so, the appellants have not presented any argument to warrant the interference of this court with the finding of the lower court. The issue, again, is resolved against the appellants.
Wow. Okay. So, anyway, like I said,
issue number 5 is whether the lower court was not in error in striking out several paragraphs of the petition and the replies of the appellants on the ground of vagueness and lack of specificity and for being new issues, mere denials, or being repetitions. Well, this issue relates to the ruling of the court below on the first respondent's preliminary objection, seeking an order of court striking out 31 paragraphs of the petition on the ground that they were vague, generic, imprecise, and lacking in specificity to elicit reply from it, and contrary to paragraph 4.1 of the first schedule to the Electoral Act 2022. The court, after scrutinizing each of those paragraphs in a well-considered ruling, struck out 10 paragraphs, namely 92, 95, 98, 121, 126, 129, 133, 143, 144, and 146 for being vague, imprecise, and lacking in particulars. For the purpose of clarity, the court held on page 8025 to 8026 of the record as follows. The sum total of all the foregoing is that while paragraph 129 and 133 of the petition are liable to be struck out for non-joinder of necessary parties, to which Messrs. Adejo and Governor Yahaya Bello of Kogi State accused in the petition of committing electoral malpractices, paragraph 92, 95, 98, 121, 126, 129, 133, 143, 144, and 146 are vague, imprecise, and lack of particulars, and so fall short of the requirements of paragraph 4(1)(b) of the first schedule to the Electoral Act 2022. They are therefore all others struck out. Paragraphs 93, 94, 96, 97, 99, 100, 101, 102, 104, 105, 108, 109, 110, 111, 112, 113, 14, 115, 116, 118, 119, 120, 122, 125, 130, 134, 138, 139, 140, 141, 42, 145, on the other hand, are in order and properly pleaded, end of quote. Picked by the above ruling, the appellants now seek the interference of this court on the ground that their vehemence were sufficiently detailed. They also question the decision of the court striking out their replies to the respondents' replies to the petition. For instance, as touching on the disqualification of the second respondent from contesting election for the office of president, which particulars were supplied in the appellant's reply. It is instructive to note that in paragraph 146 of the petition, the appellants simply averred that, quote, the second respondent was at the time of the election not qualified to contest the election, not having the constitutional threshold, end of quote. They did not supply the particulars of the threshold, which they perceived disqualified the second respondent from contesting the election, as enumerated in section 137 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. Howbeit, in their reply, the appellants ruled out monstrous particulars of disqualification by reason of dual citizenship, allegation of being an ex-convict in a USA district court, having forfeited to the USA the sum of $460,000 in a drug-related case, Note that these particulars referred to as further details were brought in by the appellants at the time when the respondents had lost their right of reply, which in essence offends the cardinal principle of fair hearing expressed in the Latin maxim audi alteram partem, meaning let the other side be heard as well. Paragraph 4(1) of the first schedule to the Electoral Act 2022 provides that an election petition shall A, specify the parties interested in the petition, in the election petition, B, specify the right of the petitioner to present the election petition, 3, state the holding of the election, the scores of the candidates, and the person returned as the winner of the election. And 4, state clearly the facts of the petition and the grounds on which the petition is based and the relief sought by the petitioner. It is clear beyond a peradventure that the requirements of the law is as provided above, is that the petition must demonstrate with specificity the complaints of the petitioner and the relief sought from the court. It gives no room for vagueness and imprecision. This is in line with the rule of pleading, that where an averment is not supported by evidence, the averment is deemed abandoned. For, in keeping with the Audi Alteram Partem rule, to prevent surprise or ambush on the defendant, it is the plaintiff's claim that will enable him to file his defense. See Wayne West Africa Limited and Econife citation supplied, Akonde and Adisa and another citation supplied, PDP and INEC citation supplied. It follows, therefore, that a petition must be detailed and comprehensive on material facts depending on the relief sought, and not evasive or vague, so as to elicit a response from the respondents. Indeed, by the provision of paragraph 16, sub 1A of the first schedule to the Electoral Act 2022, the Act frowns at the introduction of new facts, grounds, or prayers tending to amend or add to the averments of the petition in the petitioner's reply. In fact, a petitioner is only required to file a reply in answer to new issues or facts which may be raised in the respondent's reply, which were not dealt with in the petition. This means that where there are no new issues or facts raised in the respondent's reply, there would be no need for the petitioner's reply. See Oni and Oyebanji citations supplied. I have critically considered the arguments of parties contained in their respective briefs of argument vis-a-vis the record of appeal. The affected paragraphs of the petition relates to allegation of wrongful cancellation of polling unit results in various local governments in Sokoto State without particulars, manipulation of results in unspecified polling units in some local government areas of Kogi State, wrong results entered for the appellants in unspecified polling units in Borno State, criminal allegations against Honorable Adejo and Governor Yaya Bello without joining them as parties to the petition, open-ended allegation of disqualification against the second respondent, and tying critical allegations of corrupt practices in the election to a statistician report prepared by one Samuel Odutan, that's PW21, without serving the said report on the respondents along with the petition to enable them respond thereto. I am unable to agree with the appellant's argument that the lower court was wrong to have struck out the affected paragraphs for disclosing no particulars, together with some replies in the appellant's reply brief, which sought to bring in new evidence through the back door. I uphold the decision of the lower court, striking out the affected paragraphs and replies of the appellants for being vague, imprecise, lacking in particulars, and seeking to ambush the respondent via the petitioner's replies. The ruling of the lower court is unassailable, and this court will not interfere. This issue, again, is resolved against the petitioners. Issue 6 is whether the lower court was not in error in its evaluation of the evidence of the appellant witnesses on the burden of proof and clear admission against interest made by the first respondent. This issue turns on the averment of the first respondent in paragraph 8 of his reply to the appellant's petition, that the appellants in this case won the contested election in 21 states out of the 36 states of the Federation, namely Adamawa, Akwa Ibom, Bauchi, Bayelsa, Borno, Delta, Ekiti, Gombe, Jigawa, Kaduna, Katsina, Kebbi, Kogi, Kwara, Nasarawa, Niger, Osun, Sokoto, Taraba, Yobe, and Zamfara states. The appellants contend that such averment is tantamount to admission against interest by the first respondent. They therefore question the declarations to return of the second respondent as the winner of the said election. On its part, the first respondent contended that its said admission is of no consequence, having regard to the fact that the appellant scored 6,984,520 votes, as against the second respondents who scored 8,794,726 votes. That in determining the winner or loser in an election to the office of president, the number of states won by a candidate merit any consideration except in the context of geographical spread and ensuring compliance with the constitutional requirements. In its evaluation of evidence on the issue, the court below on page 8238 of the record had this to say, quote, "The table referred to by the petitioners is the table of results declared by the first respondent. There is no other set of results placed before this court by the petitioners to form the basis of our finding of fact as to whether the declared result is wrong or not. Success or failure in an election depends on figures, which is in turn dependent on votes garnered by each candidate. So, where the complaint in an election petition is that the candidate returned did not poll majority of the highest votes in the election to be returned, as contended here by the petitioners, not only must the figures disputed be pleaded, the figures of votes the petitioner perceives as correct figures of the election ought to and must be pleaded. The court went further to hold on page 2854 of the record that, quote, Section 134 sub 2 of the 1999 Constitution talks of the highest number of votes cast at the election if the contest was among more than two candidates, as in the instant case, not majority of votes cast as propounded by the petitioners. The first respondent was therefore right from the results declared by her in the absence of any rival or alternative result placed before this court by the petitioners. That the second respondent, who scored 8,794,726 votes as against 6,984,520 votes scored by the petitioners in the election, scored the highest number of lawful votes cast in the election, end of quote. The above statements, qua holding of the court, represent the correct position of the law, and I wholly endorse same. I have earlier in this judgment resolved the issue of electronic transmission of results, which is the main thrust of the appellant's contention in this appeal. I shall not revisit the point under this issue. On the contention that the first respondent's averment that the appellant won 21 states out of 36 states of the Federation, thus constituting an admission against interest, the position of the law is well settled, having regard to who can be declared winner of a presidential election in Nigeria. Section 134, sub 2 of the 1999 Constitution makes it explicit that, quote, a candidate for an election to the office of president shall be deemed to have been duly elected where, there being more than two candidates of the election, A, he has the highest number of votes cast at the election, and B, he has not less than 1/4 of the votes cast at the election in each of at least 2/3 of all the states in the Federation and the Federal Capital Territory, Abuja, end of quote. In this appeal, the issue before us is not who among the candidates won in the majority of the states of the Federation, which is debatable, but who scored the highest number of votes at the election. I have strenuously combed through the respective briefs of the parties vis-a-vis the record of appeal. I am unable to find any alternative figure put forward by the appellants as their rightful votes scored in the election, other than the scores presented by the first respondent, INEC, showing that the second respondent scored the highest number of votes, it is presumed correct. In the case of Abubakar and Yaradua, citations supplied, this court held that, and I quote, election results are presumed by law to be correct until the contrary is proved. It is, however, a rebuttable presumption. In other words, there is a rebuttable presumption that the result of any election declared by a returning officer is correct and authentic, and the burden is on the person who denies the correctness and authenticity of the return to rebut the presumption, end of quote. See also CPC and INEC, Buhari and Obasanjo, Hashidu and Goje, all citations supplied. Following from the above, it is clear that the appellants, having not put forward their perceived rightful score to rebut the result put forward by the INEC, the law presumes the first respondent's version as correct. It would not matter whether the appellant can prove having won more states or if the first respondent admits that much. The figures before us shows that the second respondent won the highest number of votes and was accordingly returned elected. From whence, therefore, would we manufacture evidence to support the appellant's claim that they scored the majority of lawful votes cast at the election, or that there was non-compliance with the Electoral Act, which affected the credibility of the election? Nowhere, definitely not from the evidence on the record. And that is why this issue is resolved against the appellants.
So,
finally,
so you can all see now.
Let me say a few words concerning issue number 7, which is whether the lower court was right in its use of disparaging words against the appellant in its judgment, evincing hostility and bias against the appellants, thereby violating their right to fair hearing and occasioning grave miscarriage of justice. I have read the judgment of the court below, and I've seen the context which those words were used, and it is my view that they were not meant to disparage the appellants or their counsel. As judges, we are trained to be temperate in our use of words, and we shall continue to do so. Litigants are advised to trust the court whenever their matters are before it. It is very unbecoming these days that while a matter is pending in court, litigants engage in press conferences, analyzing the case, reaching conclusions. Based on this, some of their followers send threatening messages to judges and justices. Matters in court are said to be sub judice, and as such, parties and probably their counsel should refrain from media trial and media judgments. I need not say more on this. A word is enough for the wise. This issue has nothing positive to offer the appellants. On the whole, having resolved all the issues against the appellants, it is my view that there is no merit in this appeal, and it is hereby dismissed. The judgment of the court below, delivered on the 6th of September 2023, affirming the election of the second respondent as the duly elected President of the Federal Republic of Nigeria, is hereby affirmed. I shall make no order as to costs.
Okay.
My learned brother on my right will deliver his judgment.
So they've thrown the case out. Okay? The case has been thrown out.
Well,
and I think we need to just
my lords,
accept that that's what it's been said.
Senior counsel and all other counsel.
I reiterate my point.
This time around, it will not be a 12-hour judgment. So, my Lord, Honorable Justice Okoro has said it all, but we must agree. So, having had a preview of the judgment of my learned brother, John Ian Ikoro, JSC, availed me with a copy of the said judgment just delivered in
Once you say that, don't focus on what they're saying. Focus on what we can do.
Atiku Abubakar,
okay?
And the Independent National Electoral Commission and others.
Don't worry about it. What can we do?
I completely agree with the critical analysis
is what we can do.
of both the oral and documentary evidence
they're going to do what they're
presented before us
the verdict
in this
is going to
appeal.
keep. I knew that the president will remain. And that is
Therefore, I agree with my learned brother that the motion of the appellants filed on the 6th of October 2023 for leave to the appellants to adduce fresh or additional evidence is devoid of any merit.
Please, share this
I
broadcast.
also dismiss the same.
We need to focus on what we
can
change as people.
My learned brother,
and I'm telling you,
resolved all the issues, the 7 issues against the appellant.
On this platform, I am telling
you,
you possess the powers that you see on the
issues
in the main appeal effective change within your community from today.
And they are
you can instruct the government to fix the foreign refineries from today.
I also did not make any
Whatever
order
they
as
decide
to
in that
cost,
court will not
but
improve
affirm the judgment of the
Whoever
lower
they bring
court,
in, it will not change your
declaring
life.
the
Don't
second
focus on
respondent,
something that is meant
Bola
to just
Tinubu,
distract you.
as the duly
Whoever
elected president of the Federal Republic of Nigeria in the election of the 25th of February
your participation in your government on a daily basis, using the powers on the screen, will change things. I urge you,
my learned
share
brother
this
to my
broadcast.
immediate left
Make
will
people
deliver
know
his judgment.
this is the power we possess, and we are going to teach you how to use those powers. 14-2-way states, sovereignty belongs to the people of Nigeria, from whom the government, through this constitution, derives all its powers.
Just delivered by
14-2-way. Memorize that,
brother,
and I'm urging you all,
Okoro
memorize
JSC.
it. 14-2C, the participation
Has
by the
comprehensively
government shall be ensured in accordance
presented
with the provisions of
all
this
the
constitution.
Furthermore,
Furthermore,
I made
I state again,
and the views I expressed
please go to
at the conference of the Honorable Justices of this panel over the appeal.
Download or
He has very proficiently presented
on there. And
all the views which I expressed
in Yoruba
in respect of all the issue
our communities in our local language.
in both the motion for leave to adduce or produce fresh or additional evidence, as well as the first respondent's motion to strike out some grounds, and the main appeal itself.
We're not there yet. Don't worry about what they're doing now.
But I would like to say
you
that
have the power to begin to hold into account. That's what we're
the
trying
point
to say
raised by
Please.
the learned senior counsel for the appellant,
Let me, I don't
Chief
want
Chris
to even-
Uchezian,
Let me see if I can mute it.
particularly in
So,
respect of the
I will bring this
application of
picture
Section
back from time to time.
285(6)
Take a screenshot of this
of the
picture.
Constitution.
I need you to take a screenshot of what
Appears
you see
to
on
me
the screen.
interesting,
Share it. Share.
attractive.
We can no longer wait around. If
But
you're waiting for these people to make
when
changes
taken
they
along
want, let me show you
with the
what I mean.
relevant provisions of the
Right,
Constitution,
okay. So I'm going to try and see if I can
as
mute
well as the Electoral Act 2022, is with respect to Chief Uchezian Specials. As demonstrated in the lead judgment, the provisions of Section 285(6), even if the Court of Appeal is not specifically mentioned in that section, the provisions of Section 285(6)
So I'm just
is
going to put
applicable
this here because
and
we need to
apply
take collective action.
to all proceedings in respect of all petitions, whether before tribunals or the Court of Appeal sitting as a court of first instance trying a petition named presidential election petition. for which it was conferred or vested with the original exclusive jurisdiction to try and entertain under Section 239(1)(a) of the Constitution. So I completely agree. This is an interesting point, like I said, because this is the first time it is coming up, and it is good that this court will make a firm pronouncement in order to avoid further or future arguments in respect of this particular issue. In addition, the issue of a candidate scoring 1/4 of votes in the FCT has also been settled by this court before now. And it is in line with that decision and position that the lead judgment
don't worry about what is being decided in the courts. Worry about
the FCT
using how to can begin to use the powers that we possess as citizens.
Elevated to a higher pedestal than any of the states of the Federation.
Worry about
it is
how we can
for the purposes of the presidential election, one of the states for which a candidate is required to obtain at least 1/4 of the votes in 2/3 of each of the states. So I totally agree with the lead judgment that this court lacks the requisite jurisdiction to entertain the application for leave to produce fresh or additional evidence, and that this appeal is also lacking in merit and deserves to be dismissed. I also dismiss the appeal, and that will be my judgment in this appeal. I abide by the consequential orders made in the lead judgment on cost to be borne by the parties for the prosecution of this appeal.
Okay, so you see that now? Now, our focus need not be about what they are doing in those courts. How can we help our people to empower them to know that their sovereigns are stated on the screen that you're watching? What steps can you take? Are you willing to be part of this process to empower people through proper knowledge? Join Citizen AY. There is a group that we have on Facebook. It's called Citizen AY Constitutional Awareness Action Group. Now
I must say that I have
the knowledge about the rights that they possess
read that
in
judgment,
704 local government areas, and begin to hold
and I'm
them
very
to
much
account. We are going to be running
content
how to teach people
and appreciative
critical steps collectively within the community,
with the
whereby
far-reaching,
they can hold those they elect
erudite
to office
reasoning
It doesn't matter what
and
they say
conclusion
in the court.
that have so far been
It's
reached
not going to, right now, the
in the
naira
lead judgment.
is 1,500 naira to $1.
Concur
That is cruel beyond words.
with the highest
That is
sense of responsibility,
beyond words. And I
the
want you all to please
reasoning and
let
conclusion
us take collective action.
reached
Now
there.
we have the power. I want you to believe
With
in
particular
possess that
regard
power.
to the
So let me see the current rate of naira.
interlocutory
Right now. The current rate as it is right now.
application,
Let me show you what I'm
thereby
saying.
urging upon this court
Okay, so let us see now.
to grant leave
Okay, as I speak to you right now,
to the
the naira,
appellants
if we were to change from naira
to procure
to the pounds, it is
and transmit
507 naira
fresh
to the
or additional
pound. Right
evidence
now. Right now.
at
Right
this
now, as I speak
crucial
to you
point in
at
time of the appeal.
11 quarter to 12
I
this morning.
Concur
That is the biggest concern. It doesn't matter who the president is. They
most
cannot change
assiduously with
anything
the
because they are wedded to this colonial
conclusion that has been
structure.
reached
They are sworn to secrecy
in
to
the
protect
judgment
that colonial
of my learned
structure
brother
at
that
our
such an
expense.
application is
We
grossly
need to exercise the
unmeritorious,
powers that the state
thus ought to
in
be
that constitution to hold
dismissed,
them to account.
and same
When
is
we
accordingly
exercise our
hereby
power,
dismissed by me.
We will force them
And
to
as for
comply
the
with what we, the
substantive
people,
appeal
want, not what the
itself,
colonials want. That is the difference here.
which has
And I
been
hope many
predicated
people are
upon a
understanding
total
what
of
I'm saying.
7
please,
issues.
don't wait around. We're not here to, don't mope around.
I agree entirely
We must take collective
with the
action.
reasoning.
Help us share this broadcast. Help us share this broadcast to reach as many people as possible.
Eruditely expressed by my learned brother that each of the 7 issues that have been canvassed and argued by the appellant
and that is what we're trying to do.
are grossly
It doesn't matter. It doesn't matter
unmeritorious.
what the judgment is.
Thus ought to
And
be
it will not make
resolved
any difference.
against them. Without
It
much
will
ado,
not make any difference.
I
Okay? It will not
hereby
make one blind
accordingly
difference.
dismiss the
Whoever
appeal
came
for
in,
being
The
grossly
fact of the matter is
unmeritorious.
that we still have no refineries. And
As
I'm telling
usual,
you today,
it is not the time for
the
us
government may be willing
to
for
read
the refinery to
elaborative
be fixed by Saturday,
judgments.
by this December.
just like my brother,
But we
learned
know
brother
that
said,
that target will not
12
be
hours.
met.
We're not
So
going
they
to
have
do
all
that
the will,
because
they are
learned
trying
counsel
in many
representing
ways,
the
but it is
respective
not, because the
parties in
overall
this
structure
appeal
is to create
will have every
dependency
opportunity
on using
to
the
be
structures
served
created by the
with
colonials.
the complete judgments
keep
of
us
each and
trapped in our
every
own land.
justice
The only
this
people who
panel
can free ourselves is ourselves.
in due course. Because constitutionally, we have a total of 7 days within which judgments must be
None but ourselves can free our
served
mama.
on the respective learned
Have no
counsel.
fear for atomic energy.
Thank you very much.
'Cause none
My
of
Lord
it
Jaro,
can
read your
stop
judgment.
our time.
Well, I've had the privilege of reading before now the lead judgment delivered by my learned brother, John Ian Okoro, JSC. His Lordship has ably considered and resolved all the issues in contention in the appeal, as well as the application. I agree with the reasoning and conclusion reached therein to the effect that the appeal is bereft of merit and deserves a dismissal. The application, too, is not meritorious. Accordingly, I dismiss the application and the appeal. That is my position.
My Lord Abubakar.
One more time. Emancipate yourself from mental
I
slavery.
thank my Lord the Presiding Justice, Honorable
None but ourselves can
Justice
free our mama.
John Ian Okoro,
Have no fear
for granting
atomic
me the
energy.
privilege
'Cause none of it
to read
can stop
in
our time.
draft the
How
lucid
long must they kill our
and
prophet?
illuminating leading judgment
Our wives with them
just
inside
delivered
and
in this
love.
appeal.
Oh,
I start
it's just
with the application. The application seeking to adduce additional evidence or fresh evidence,
Won't you help me sing
I also find it lacking in
this
merit.
song of freedom?
The application is frivolous
Is all I
and
ever
vexatious.
had. Oh, yeah.
It deserves to be dismissed, and it is hereby dismissed. Now, coming to the substantive appeal, I find no merit in the substantive appeal. It is also dismissed. On the whole, therefore, the appeal is dismissed and the judgment of the lower court is affirmed. Parties in this appeal shall bear their respective costs.
Don't wait on whatever the court is saying.
Yes, Iroko.
Have the power to
I
make
give
this
JSC.
I restate, I emphasize that point.
With the kind
You
permission
have
of
the power.
the learned
What is
presiding
done
justice,
here, you can change. But
let
what you
me
can't change
also
is what we need to
express
focus
my
on.
view.
And I'm trying to.
I had a
hopefully
preview of the
get us
judgment
to,
delivered by my learned brother, Lord
um,
Justice
you know,
John Inyakoro, JSCFR. I completely agree
so
with the reasoning, conclusions, decisions, and others therein. And I must remark that it is
so I'm
briefly
just putting this up
with
together.
commendable erudition. Let me, however, say maybe one or two things
What I will say to you all,
we will have opportunity.
I don't want
have
anybody to
opportunity
waste
to have
your
our
time.
views.
Don't waste your time.
That the
thinking,
deposition
what
is
they've done.
for this
Don't
additional
lament
reason
over this.
inadmissible.
I wouldn't waste my time.
So if a document is
I wouldn't
inadmissible,
waste my time. You know.
you cannot ask that you should be allowed to bring it in as fresh evidence. A reading of the deposition exposes that it is not authenticated by the seal of the authority before whom it was issued. A deposition from another country to be used in Nigeria should prima facie bear features of authentication, such as the official seal of the court where it is sworn, if it is the court, or if it is before a notary public, his seal or signature, or if sworn before a person legally authorized to take the seal, or if sworn in the Nigerian Embassy, High Commission, or consulate in that country, the signature of the officer authorized to do so, and the seal of the Embassy, High Commission, or consulate.
So,
such authentication is an
I don't
assurance
think we need to
of the origin
belabor the point.
and authenticity of the foreign disposition.
Let me see if I can do something.
In our
like this.
present case, the certified shorthand reporter, before whom the disposition was made,
I just want us to be aware of something, and I'll play it again. Look, whoever won this, the situation remains the same. Our people are suffering. As we speak right now, the naira is 1,537 naira to the pound. Similar territory with the dollar. You know, what we are saying here is this. You need to participate in your governance. You need to participate in your governance. So whatever they
deposition was
say,
made, did not authenticate the deposition with her seal. She merely signed a certificate of reporter bearing her name and number, page 126 of Exhibit C. Being a deposition from another country, was not made before the court in the said proceedings. And if made elsewhere in the law office of the first appellant's attorney, why was it not filed in the above-mentioned court? Because of the peculiar circumstances of this case, and adopted as a deposition ordered by that to be made by the court, so that it can form part of the record of that court to enable the court issue it as part of its record,
give me 1 second.
and so authenticate it with the seal of the court and the signature of the relevant officer of the court.
One. Just give me
Page 1 of the
sec.
deposition is headed in the United States District Court for the Northern District of Illinois, in reapplication of Atiku Abubakar for an order directing discovery from Chicago State University pursuant to 28 U.S.C. 1782 number 28 CV 05099. This gives the impression it is a process of the district court, or that the deposition, though made outside the pressing private law office, is part of the proceedings in case
So
number
I'm
303,
just trying to check something. So beg your pardon.
05099.
Do
If
beg your
it is
pardon.
if it is indeed a process of the said district court,
That's not the
or forms part
one.
of the proceedings in
Beg your
case
pardon.
number 23
We'll
CV
find it. It's just
04099
being difficult,
before
but we're there. We're there. We're
then
there.
it ought to have been authenticated
So,
by the official seal of the court and the
so
signature of the
we're
relevant
back. I
officer
think you can
certifying
see
it
me now.
as a true
And I do apologize for
of the part of
the
record
sudden,
of the court in case number
the way the
23
pictures
CV
went there.
05099.
But
Without such
I wanted to be able to
authentication,
control the volume.
deposition cannot be used in the Nigerian court.
Whatever is said here, what I will say to you is that whoever won this election would have not made one blind bit of difference. The price of the naira would still be high. It's the entire structure that needs to come down, and we have to participate in the process, using the powers of sovereignty to hold for the first time, perhaps, no, not perhaps, to for the first time in 24 years, hold those who elected to office to account since 1998. The election in 1998 has proven to be a very watershed moment in terms of elections. What we're saying is that whatever is decided here, whatever they say here, it will not make any difference to the sufferings of the people whoever is elected. The people that will make the biggest difference to their suffering are the people through active participation in the governance, as stated under Section 14(2)(c) of the 1999 Constitution, which is what you see on the screen. I don't want you to belabor that point. I ask you to please, we need each other now to redouble our efforts. The only way to turn this around in the short to the medium to the long term is our consistent and active participation in our governance using the two powers that you see on the screen. 14(2)(a). The participation and sovereignty belongs to the people of Nigeria, from whom the government, through this constitution, derives all its powers and authority. We need to exercise those powers. We need to exercise those powers. So, yeah. So, I cannot overemphasize how important it is for us not to waste any time shedding any tears over this, but instead to now use it as an opportunity to go, okay, you know what? We get it. We get what's happened. Don't play the game of the politicians. It is time we start playing our own game. We have the power to participate in our governance, and it is only through our active participation that we will make a change. It is only through our active participation. So I urge you, share the broadcast. I will probably restream it later on Facebook. But what we need to do here, whatever else they said here, it doesn't make any difference. The people are still suffering. There is hunger in the land. Though we know the government are trying in their ways, but they're not doing the fundamentals. The fundamentals has to be right. They are manufacturing base. They need to encourage our people, whoever they are in all our governance, to buy the nation's product, not rely on foreigners. The more you rely on foreigners, you're using our foreign exchange to buy goods that make us dependent on those who have put us in this situation. And many of our leaders need to really wake up. I'm not here to cause our angry or cause any. There's no need. But I'm here to try and make sure that the powers that you see on the screen, I bring it to your attention, and I hope at some point many of us will take heed of the powers on the screen and will actually use those powers to hold our governance to account. It is not about just trying to make noise and sort of, we need to save our energy. Focus on the power on the screen. Again, you can go to www.citizenny.org and then you download the Ìwé Òfin 1999 ní èdè Yorùbá within that constitution, within that website, and begin to use it in your communities. We're going to try and bring more updates about what we're doing and how we're going to do it. We will need each other in this struggle. The political part, we should not expect any help from the politicians. What we should be doing is to make sure that we, the people, begin to actively participate in our governance. That is the only way. Those in government now, they are wedded to that structure. They are bound by that structure. They cannot, even if they wanted to actually help to alleviate our concerns, the agreement they've reached into, tied their hands, they are not able to do anything because they just want to ensure that we have continued dependence on products and things from the colonials. That's what the structure is about. So that's what I'm saying. It's not about calling person Jagaban this or Atiku that, or yeah, fine, you can say that, but it's not going to solve the fundamental issue, which is that our people are suffering. So I hope many of you are seeing what we're seeing. We may restream this later on.
Judgment day, you don't go late to court.
I was here before, I was here by 8 o'clock, sir.
So that you won't be late when God will be giving judgments.
Oh, my Lord, on the day of my own judgment before the Lord, I will be there alone. So I will not be late there.
So,
and I'm sure you will accept me when I get there, sir.
God will accept you.
I'm sure you will.
I pray it should be so.
Amen, sir. My Lord, I want to say that my name is P.I.N. Ikwetu, and your Lordship, with respect, we have, in line with your Lordship.
I think we should start calling you Saint Ikwetu.
My Lord, I cannot be while still on earth. Yes, sir.
Until you die.
While still on earth, I cannot be. I'm a sinner.
Let's find a place and discuss that.
I don't please. My Lord, I don't know where we can discuss that, sir. My Lord, we've taken the
So
liberty to
President Tinubu remains the president. I said that at the outset. I said it days before. I said I don't see any reason how that's going to change. And anybody that was putting their mind up thinking that they would change on the basis of what was said, you should see the writing on the wall. There is a precedent. President Tinubu, President Buhari did not have certificate, ran the country for 8 years. So it stands to reason that even if the debate about whether or not Tinubu had it, that's already precedent. This means that it's not suddenly going to change because of it's not suddenly going to change. What we need to focus on is how to ensure that we begin to hold our governors to account using the powers of sovereignty that I'm showing you on the screen. That is what we must do. All of us. We need to exercise our powers of sovereignty and teach our family and friends and our community to come together and exercise those powers. Without exercising those powers, the suffering of our people will simply continue, sadly. That's the reality we face. We cannot afford to be bystanders anymore in our own governance. We must participate. We must get rid of any of those things they put in front of us to distract us. Religion, of Christianity, Islam, and tribalism, and all this stuff. They are using it to divide you, keep you divided, and to keep you oppressed. We need to exercise the powers as sovereigns. We are more than that tribalism and the religion. We are the powers that we possess is more powerful. The Constitution of Nigeria is more powerful than the Quran and the Bible combined. And that's what I want you to know. So let's watch for a bit more.
Stephen Adehi, my lord. Sir Stephen Adehi.
See, let's hear.
Adehi.
Yes, my lord.
Yes.
I appear with my learned friends of the Inner Bar.
Yes.
Al-Hassan A. Umar, S.A.N., is number 4 on the list.
Umar.
Yes, my lord.
Yes.
And number 7.
The verdict has been reached anyway. Tinubu remains the president. I said it before.
Yes.
If you go and look at my broadcast, I could see the writing on the wall.
Yes.
That doesn't matter.
Number 8.
To be honest with you,
Aguru,
those of you
Esquire.
getting involved in that and thinking that will change things, we are missing the ball, missing the
Where
game.
is
The
Jamiu
game we should be playing is
Aguru?
encouraging our people, spreading the knowledge of the right we possess as citizens,
finally, number
as
10,
sovereigns,
Z.
and how we can use it to hold them to
Esquire.
account. 14.2a. Sovereignty belongs to the people of Nigeria, from whom the government
Our
through the
appearance,
constitution
my
derives all
lord,
its powers
is
and
for the
authority.
first
We need to exercise those powers. We have
May my laws be
to date
pleased.
we have not exercised it collectively.
for the-
We need to begin today. And then it talks about section 14 2C. The participation by the people in the government shall be ensured in accordance with the provisions of this constitution. These are things we need to do. It doesn't matter who's in government. Are we holding them to account? It doesn't matter who is in governance. The question we should be asking is, are we holding them to account? Are we holding those we elect to office to account? Yes or no? If we are not, then we need to address that issue. And I'm putting to before you all, in the court of public opinion, in the court of the sovereigns, that we have not exercised our powers of sovereignty that I show you on the screen. What they are doing on here is just is something for you to just. I don't think you should. For me personally, I don't personally believe that we should be wasting our time even talking about this. I don't think so. I think we need to be looking at what steps we can take collectively within our community right now. Monthly allocation going into the states. Where's that money going? All of this, we should be focusing our energy to question them using the powers of sovereignty. Reminding them at every meeting. The meetings, I've said it, on the walls of every building, they should have the words you see on the screen. Sovereignty belongs to the people of Nigeria, from whom the government, through this constitution, derives its powers and authority. That should be on every wall in all government offices and then the offices of the ministers and the president to remind them who they are serving. These are the kind of things we need to do. And of course, in our local community associations, we need to have this on the wall of those properties. So,
and I appear with my colleague.
Yeah.
Okpe Moritala.
I mean,
Your Lordships, we submitted a typewritten list in the morning. Very respectfully, our appearance is for the second and third respondents. We are very grateful, sir. Okpe Moritala, my lord, is number 2 on the list.
Yes.
So they've moved on now to the next judgment, it looks like.
Yes. Yes. Yes.
Appearing with me, I'm Leonard Friends. My lord, I'm sorry, the next name is not on the printed list which we submitted.
Let me, okay, here.
Professor Abdul Karim Kana. And Abdul Wahab Abayo.
Please use the powers on the screen. Sovereignty belongs to the people of Nigeria, from whom the government, through its constitution, derives all its powers and authority.
Appear for the 4th
We're going to watch this for a while. I may mute the screen, mute myself, and go away and get one or two things, and I'll come back. But we need to understand something. It is time we begin to collectively exercise our powers of sovereignty that you see on the screen. By the way, if you haven't taken a screenshot of this, take a screenshot. Don't forget, go to www.citizenay.org for you to get to read in Yoruba the 1999 Constitution. It's up to section 53. But that many parts of that is what we need for our people to begin to hold our governance to account in our local languages. I reiterate, many of us, we need to have the constitutional and local languages so we can begin to hold those who are elected to office to account. That is what we must do. I'll probably come back and expatiate it more on that. But I do tell you the breaking news is that the fact is that President Tinubu remains the president, and I wasn't surprised. I'm not surprised, and many may be surprised. I'm not surprised. The precedent has been set the minute that Buhari, with his non-certificate, was allowed to be president for 8 years. That's a precedent. Like it or not, that means that anybody that comes subsequently after him will be able to do that. Regardless of whether or not they have a certificate or not, regardless of whether the certificate is fake or not, a precedent has been set. And that is what we need to understand. A precedent has been set. And until, this is why we are calling for us to go for participate in our governance so we can go for self-determination. Because right now, the constitution has to be changed. But I don't see how that's going to happen anytime soon, unless we actively participate in our governance using the powers that you see on the screen. So that is what I really wanted to state. Let us see how these are going. I'll let them talk for a while, and I'll be here. But let me just and I'll come back and say some more things. Please do share the broadcast that you're watching. Don't forget to subscribe to Citizen AY, the platform where we speak truth to power. So let us just do this.
Have been dealt with in Atiku's appeal.
So subscribe to Citizen AY, hit notification button, give us a thumbs up, help us reach more people. We really do need your support. As we speak, the Naira is now pushed through 1,537 Naira to the pound. And it's the same thing for the dollar, over $1,500 for 1,500 Naira for $1. I mean, we need to think about what's going on. So let us see what's going on. I'll meet for a minute. I'll be, let's follow it for a little bit. I'll come back. I'll talk some more. Please do share. Don't forget to subscribe to Citizen AY, the platform where we speak to the power. I urge you. I'm empowering you. I'm urging you to empower your community. We need to participate in our governance. That is the only way we can bring the change that we wish to see. We can no longer be bystanders in our governance. We must actively participate. And we will talk you through how we can do it. We should be able to, we must by now be having monthly meetings with just local government chairman, state house assembly, house of reps, and senators, demanding questions for them in our local languages, and they're answering us. And then we say, in Yoruba land, for example, when you got the local government chairman, state house assembly members, house of reps, and senators into the meeting every month, before the meeting, you read to them. In my case, if you're in Yoruba land, read to them like this and say, you remind them about the powers you possess as sovereigns. Ìjọba jẹ́ ti àwọn ènìyàn Nàìjíríà láti ọ̀dọ̀ ní síjọba nípasẹ̀ òfin orílẹ̀-èdè gbogbo agbára àti àṣẹ nítorí wà nínú ìwé òfin nìyẹn. So you remind them that that's what's in the constitution. We need to begin to do that collectively. We have to teach our people how to do that, because that is the only way we can confront and defeat this oppression that is
I
going on.
agree with my learned brother,
Our people are
Justice
suffering.
John Ian
So
Okoro.
anyway, let's listen to a few minutes and hear what they're saying. So like I said, the breaking news is that President Tinubu remains the president. I'm not surprised. Many will be surprised. I wasn't surprised. I always knew this was what the case was going to be. It wasn't going to suddenly change. So let's watch for a few minutes.
Lacks merit, and it is also
I'll be back
dismissed
shortly,
by
but please do watch, leave comments. Let us see if I can get this going.
I also totally agree with the lead judgment that this appeal substantially canvass the same issues with the appeal number 935/2023,
Second.
which this court has very comprehensively dealt with.
Okay.
And
So, yeah.
there is no need for us to repeat ourselves because the issues are the same. The only issue that's different, like pointed out by my learned brother, the PJ, is that about double nomination, which you have settled. And we do not intend to reopen it again in this appeal. On the whole, I also join the lead judgment to dismiss this appeal for lacking in merit.
My Lord Salawa.
Yeah, what they said is that the case lacks merit in their opinion. Who are we to say no? The system is protecting itself. We, the people, must participate in that process using the powers of sovereignty. Again, I'll put it on the screen before I move off for a few minutes. Again, if you haven't got a copy of this, have a copy of it. Sovereignty belongs to the people of Nigeria, from whom the government, through this constitution, derives all its powers and authority. You possess those powers. Don't let the Bible or the Quran prevent you from exercising those powers. That's what we're saying. And we will teach you how you can use that collectively within your community in all central and central local government areas. Furthermore, the Constitution permits and says the participation by the people in the government shall be ensured in accordance with the provisions of this Constitution. Part of the provisions is that you are a sovereign, and as a sovereign, you have the right to exercise those powers. That's what we're stating. So carry on. I'll be back in a few ticks. Let's carry on. I'm going to just make a cup of tea and come back. But let's carry on.
I had the advantage of reading in draft copy of the lead judgment just delivered by my learned brother, John Ian Okoro, JSC. I entirely agree with the reasoning and conclusion contained therein that the appeal is devoid of merit and it ought to be dismissed. Consequently, I join my brother in dismissing the appeal.
My Lord Abubakar, JSC.
I also had the advantage of reading in draft the judgment of my learned brother Ian Okoro, JSC, and I am of the view that the appellants have nothing useful to urge this court. The appeal lacks merit, and it is hereby dismissed by me.
My Lord Hakim, JSC.
I had a preview of the judgment delivered by my learned brother, Lord Justice John Ian Okoro. I completely agree that this appeal lacks merit and it should be dismissed. I hereby dismiss it.
Thank you all for listening. The two appeals, I think we have concluded our job today. What remains is for us to go and rest. Thank you very much. We shall rise.
Oh, it seems that the case has been put for. It's come to an end. Okay, it seems. Let me just before I was gonna make it. Let me just quickly round this up. Then in that case, it seems as though the case has come out. The judgment has been made. We'll probably rewatch the whole thing at some point later on. But like I said, don't worry about whoever side won. That's not what is important. What is important is this. Please do not ignore this message. Share this in your community. We need to do what? Exercise our powers of sovereignty. It says here, sovereignty belongs to the people of Nigeria, from whom the government, through this constitution, derives all its powers and authority. They will never mention this to you. You notice they never mention it to you at all. We are mentioning it. We want you to become familiar with this. Use those powers. And how do you use it? You can only change things through your daily active participation in your governance collectively within all 774 local government areas. Section 14.2c states, the participation by the people in the government shall be ensured in accordance with the provisions of this constitution. As a sovereign, you are mandated in the constitution to participate in your own governance. Don't be bystander any longer. We need to begin to exercise those powers. So let's hear what they're saying there.
Take this country where it rightfully should be. We're happy. We're excited.
So coming together, does
yes.
that mean that you'll be extending a hand to the PDP and the Labour Party? Although the APM's appeal was dismissed, but would the president be extending a hand of friendship or sportsmanship to the other political parties?
Listen, we shouldn't take these things personal, right? If you listen carefully to the judgment was very sound by any objective, right-thinking person. Supported with facts, with cases, with statute. The president, if you know him very well, is a Democrat. He's not now that he's extending his hands of fellowship. He's always done that. He will continue to do that, and will continue to do so on his behalf. Governance is about everybody. It's not about a party. It's not about an individual. And if we do not come together now, then we'll have ourselves to blame. Opposition is not, you don't oppose for the sake of opposition. Elections are over, litigation is over. All litigation must come to an end. Now is the time for governance. Distractions over. So yes, Mr. President, the APC, and all rightful thinking members of the society must come together, no matter what party you belong to address the issue of governance.
Thank you very much.
Thank you very much.
People keep writing. I've just read something. Someone just said something here. It says, oh God, show yourself strong over Nigeria. Let evil men know that you are God. The only way you can change this is what I'm showing you on the screen. Here, you see? See that? Look at that. Sovereignty belongs to the people of Nigeria, from whom government through its constitution derives powers and authority. There you go. You need to exercise those powers. That is where, if you do that, then the Most High will support us. If we don't do that, nothing will change. And how do we do that? The participation by the people in the government shall be ensured in accordance with the provisions of this constitution. That's what we need to do. All of this here is all a charade. It's all a charade.
I'm sure
it's all a charade.
Now begin, reach out to all to join hands with him in his renewed hope agenda. APC was his platform, but the Nigerian state is where he's president of. So this is not just a victory for our party APC. It's a victory for the country. And we want to salute the judiciary, starting from the Supreme Court, the Appeal Court. Their judgment was very detailed. It was very meticulous. It laid the foundation for the Supreme Court judgment. I want to salute the judges of the Supreme Court as well. It was straight to the point. And I believe that this judgment would be seen worldwide as that which is in line with
congrats to them. They won. That's fine. It's not going to change what's going on. We're suffering now. People there's hunger in the land. That's what I really want us to really understand. And this man does have questions to answer. There's a man called Wale Adedayo that they've taken to court. They removed him from Ijebu South, I think, or Ijebu Ijebu South or Ijebu East local government area, I think, is being illegally removed for questioning and demanding answers on the monthly allocation for Ogun State for 2 years from Dakpa Abiodun. We hope the case is in court at the minute, so we don't want to say too much. Hopefully, watch this space will be some developments on this platform around that, but we'll see what happens. Let us, in the meantime, the question, what they're saying here, what this man is saying here is just.
Yes, just one question.
Okay, what is it here?
The court today said that the FCT has no special status. As the minister of the FCT,
maybe you don't understand when he said FCT has no special status. What he said that in terms of calculating or having the special square, you must not win FCT before you are declared president of the Federal Republic of Nigeria. That FCT is like another state. So that you don't need to say, oh, if you don't win FCT, therefore you cannot be declared. That is what he said.
So you must have start with the APC crew. Can you say that you have moved to the APC?
I didn't come with APC crew. And in the court here, I don't know where they said APC and PDP.
Well,
I came here as somebody who's interested, as somebody who wanted the country to move forward. So I congratulate Mr. President, and I think that this has come to the end. No more speculation. So Mr. President can focus. And
the citizens, we have to play our role. If we do not play our role, as citizens in our governance, then what will happen is we will continue to face oppression in our own land from our own governance. Our role is to hold our governance to account using the powers that I've told you about. But let's listen to Ganduji.
Well, you see, this is a developing democracy in a developing nation, so you expect such distractions to occur. But I believe we fine-tune our laws, especially electoral laws, and we believe we shall come to the mature stage that we are expecting. Pertaining to acceptance of this verdict, I urge our colleagues, politicians, to accept it in good faith. And also I have to use this opportunity to congratulate politicians, to congratulate the leaders of the opposition political parties, because it is better for them to resort to judiciary, which they have done so, rather than taking, arms against each other. So we have to congratulate our politicians for resorting to judiciary, and the judiciary has done well. It means that democracy is getting matured in Nigeria, and we are happy with that.
His health is in a bit of a concern because he was coughing there. You can hear him coughing away there. But anyway, look, I want you to just focus your mind on this. You need to. You've been brainwashed to not know about the powers that you're seeing on the screen, and I'm here to wake you up. Citizen AY, the platform where we speak truth to power. I'm going to come back and dissect this properly again, but I wanted to really show this so that we can get a proper understanding of what's going on. So let's look at this again to remind those of you who are watching. Jagaban has won. I told everybody, I knew this, it wasn't even a doubt in my own opinion. He's won. Tinubu has won. And what we need to do is not focus on their battles. We need to focus on our battles collectively. We are suffering in our land. And it's only by exercising our collective powers as sovereigns we will be able to put a stop to that suffering. So I urge you all, please use your powers of sovereignty. You see on the screen, sovereignty belongs to the people of Nigeria, from whom the government, through this constitution, derives all its powers and authority. Section 42C, the participation by the people in the government shall be ensured in accordance with the provisions of this constitution. These are things that we must do. It doesn't matter what party is in there. It is our own participation that is of immense importance, and we must begin now in every local government area. And we're prepared to work with all local government areas to teach collectively how we can begin to hold our governors to account. Your monthly allocation, you have the power to question your local government, your state assembly member, your House of Reps, your senators, your governors. You have that power conferred on you under Section 14.2a. Sovereignty belongs to the people of Nigeria, from whom the government, through this constitution, derives all its powers and authority. Section 14.2c. The participation by the people in the government shall be ensured in accordance with the provisions of this constitution. These are the things that we need. We need to participate in our governance. No prayer will do this. You have to participate. No prayer can do this for you. You must participate in your governance. So there you go. So that is what you see there. We may rerun this later on, but that's the news. Today being the 26th of October 2023, and the news is Jagaban remains the president. He won the case that was taken to the courts.
And that has been the proceedings from the Supreme Court here in Abuja.
Let's hear from Channels News.
Reporting for Channels Television News.
So there you go. So the verdict has been reached. What we do need to say, and I say that again before I wrap this up, I want to thank each and everybody that joined us. I want to thank you all. Sorry about that.
You've been watching a lot.
So let's just, I want to leave that there. I want us to focus. I'm going to end it on this broadcast, on this section here, and I will replay it later on, and we'll probably come and dissect it later on. What does this mean? It just means that we are yet to exercise our powers of sovereignty, and we need to begin to exercise those powers. And our role is to teach each and every one of us how we can use the powers that you see on the screen on a daily basis in our local languages. Don't forget, go down to www.citizenay.org, download the Nigerian Constitution or read it. Click on it, it will come up on your screen. Read it in your Yoruba language. We're still doing some updating on it, so it might change in its appearance, but essentially the information that contained is the same in Yoruba language for you to be able to use. We need those information to be in our local languages for our people to hold those we elect to office to account. So what's left for me to say is to say thank you so very much for joining. You've been watching Citizen AY, the platform where we speak truth to power. If you haven't subscribed to Citizen AY on YouTube, here's how you can do that. Go ahead, subscribe to Citizen AY, hit notification button, and of course, give us the thumbs up. Help us reach more people. We truly appreciate your support. I'll be back later on to dissect what all this means, unpack it. I may have one or two guests with me. I'll see how the day pans out, and we can dissect this together. But please, I don't want us to focus on what they've decided. We need to focus on what we must do to make sure we hold those we elect to office accountable, as we are mandated to do under the 1999 Constitution that was imposed on us, because it says that we are sovereigns. We are yet to use the powers of sovereignty, and I'm here to encourage us to collectively use the powers of sovereignty. It's not about abuse. It's not about calling people the names. That is not going to improve your lives. It is when you begin to exercise your powers of sovereignty that's been hidden from you for over 24 years that real difference will happen. So, please, 14.2a, memorize it, know it. Look, I know this of head. Sovereignty belongs to the people of Nigeria, from whom the government, through this constitution, derives all its powers and authority. 14.2a. 14.2c, the participation by the people in the government shall be ensured in accordance with the provisions of this constitution. 14.2c. That is what we need. You need to know this off head, and of course in our local languages. Don't forget to go down to www.citizenay.org. Go there, download the constitution. Take a screenshot of this in English. It is also in Yoruba. Don't think I'm just saying it. I've already done it, but I'm just here's one I made earlier, as it were. Let me just show you that before I wrap it up. So here's what I want to show you. So we're gonna go into this one here, and I want you to just see that, because it's important that we see that, because people seem to not realize the importance of what we're saying. The Bible is not there to help you. I know people don't like to hear that, but that's the reality. The Bible is not there to help you. So let me just show you again. This is the one in Yoruba. Just before we wrap up, I wanted you to have this in Yoruba as well. So this is what you will see on the on the website www.citizenny.org. It is in Yoruba, section 14.2c. So and it reads, nípa báyìí ó ti kéde pé ìjọba jẹ́ ti àwọn ènìyàn Nàìjíríà láti ọ̀dọ̀ ẹni tí ìjọba nípasẹ̀ òfin orílẹ̀-èdè ń gba gbogbo agbára àti àṣẹ rẹ̀. So that's section 14.2. 14.2c. Ìkópa àwọn ènìyàn ní ìjọba wọn gbọ́dọ̀ rí dájú ní ìbámu pẹ̀lú àwọn òfin orílẹ̀-èdè yìí. So those are the words in effect that it means, that is the section 42 and 42c in Yoruba language. That's what we need. We need this knowledge to be shared in all our communities. It is no longer waiting or praying to God. God is not going to come down to help. We have the tools. Let us use those tools. That's what we're saying. So, ladies and gentlemen, you've been watching Citizen AY, the platform where we speak truth to power about Latron. Please do share this broadcast. Don't waste your time lamenting about the injustice or whatever the case in your view. What you need to focus on is how are we going to make our governance accountable using the powers of sovereignty that we possess, that we are yet to use. The time is now for us to begin to use the powers of sovereignty collectively in all 774 local government areas. Thank you so very much. I'll be back later on. Thank you and bye for now. Don't forget, subscribe, hit the notification button, give us a thumbs up, help us reach more people. Thank you.